Good morning, ma'am.
Hi, good morning, Your Honor.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine.
Right out the gate. Driving while intoxicated, facing up to 6 months in jail, and a $2,000 fine. Classic DWI charge. But pay attention to how these early details shape the story. Check the timestamp, 9:20 p.m., prime after work drinks territory. This case isn't just about legal codes or blood alcohol levels. It's about real-life decisions and the high cost that can come from just one. Can a single beer really tip the scales? Let's find out.
Fine.
On July 27th, 2024, at about 9:20 p.m., officers arrived on scene and observed two vehicles that had been involved in an accident. The witness stated she had been stopped at the light when she had been struck by the defendant.
Boom! Sobriety tests coming in hot. 6 out of 6 on the horizontal gaze nystagmus, 7 out of 8 on the walk and turn, and 3 out of 4 on the one-leg stand. For those unfamiliar, these tests are meant to spot impairment by checking eye movement and balance, and when the scores are this high, it's like red flags waving in every direction. Triangular flag, but here's the twist. There's more to this story than just numbers. What did the defendant admit? And what did the actual breath test reveal? Keep watching. This one's not as open and shut as it seems.
Car. The witness stated she saw the defendant to be the driver of the car that struck her. The defendant stated she had been downtown and was on her way home. She admitted to having one beer. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 7 out of 8 on the walk and turn, a 3 out of 4 on the one-legged stand. The DIC was read and the defendant consented to a breath test. The first result was 0.175 and the second result was 0.181.
All you said is there's an accident and she had missed one beer. Was there any slurred speech, bloodshot eyes, odor of alcohol?
It looks like we just have the car crash and the admission of the one beer.
Can you hear me?
Judge, can you hear me?
Yeah. Can you hear me?
Yeah, I'm here. Yes, sir. I'm sorry. I'm down Galveston. Yes, sir. I'm here on Mrs. Morales.
Yeah. She's actually right in front of me right now, Michael.
I see it. Perfect. That's why I jumped on.
Have you heard PC yet?
No, sir.
All right. Do you mind?
Now here's the kicker. No slurred speech, no bloodshot eyes, no smell of alcohol. The judge is basically asking, where's the probable cause? This is a pivotal moment in DWI cases, where the physical signs don't always match up with the test results. The judge's doubt highlights a crucial point. The law requires more than just a crash and an admission of one beer. It's a reminder that suspicion alone isn't enough. Proof matters. What would you expect a judge to look for here? Drop a comment below.
Do you one more time?
Absolutely, Your Honor. On July 27th, 2024, at about 9:20 p.m., officers arrived on scene and observed two vehicles that had been involved in an accident. The witness stated she had been stopped at the light when she had been struck by the defendant's car.
The short answer.
The witness stated she saw the defendant to be the driver of the car that struck her. The defendant stated she had been downtown and was on her way home. She admitted to having one beer. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 7 out of 8 on the walk and turn, a 3 out of 4 on the one-legged stand. The DIC was read and a breath test was given with the first result of 0.175 and a second result of 0.181.
I didn't hear anything about any kind of slurred speech, odor of alcohol, bloodshot eyes. I didn't hear any of that, Michael, so I'm just finding no probable cause.
Okay.
You know, Miss Morales, we have enough destruction on our streets, enough death from DWIs every single day. You know, just don't kill someone, please. If you're gonna drink, if you wanna have 15 beers, 32 shots tequila, one button on your phone, $40 with an Uber will get you anywhere you want to go. Use it.
Sir.
Please.
Bennett?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20. Now, 21 cases. Just since 2020, possession 1 to 4, unauthorized use possession 4 to 200. 21, evading arrest. Felony theft, felony assault, felony possession of a controlled substance, possession of a controlled substance, possession of a controlled substance, now 24. Possession of a controlled substance, possession of a controlled substance, assault, unauthorized absence from correctional facility, PCS, now 25, just for 25, PCS, unauthorized use, and now you have an evading arrest.
Those guys.
Stop. I didn't ask you to say anything. You missed court, and now you're here. If you ever miss court again, and let me tell you something, Mr. Price, I'm going to do everything in my power to protect my city at all costs. If I find that you are one iota of danger to it, it's really not going to go well for you. Do you understand me? You're now charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one.
Hold up. Why is riding a bike a problem here? This moment dives straight into the gray area of police stops and what counts as reasonable suspicion. The defendant's choice to ride a bike, then flee, sets off a chain reaction of legal consequences. But was that response justified? It raises the timeless question: when does police suspicion go too far? It's a sharp reminder of the thin line between protecting public safety and preserving individual rights. So, what would you do in that situation?
One will be appointed to you.
Thank you, Judge. On April 14th, 2025, in Harris County, Texas, an officer was patrolling the area of 999 Pasadena Boulevard, the Macro Plaza Mall. The mall is closed during the early morning hours when this incident occurred, and no maintenance or cleaning personnel were on scene. 999 Pasadena Boulevard is near 1202 Pasadena Boulevard, which the officer knows from training and experience to be a high drug area. The officer observed the defendant standing near a mechanical box on the side of the main building of 999 Pasadena Boulevard. The defendant looked at the officer, who was in a marked patrol unit, and began walking toward his bicycle, which was laying on the ground nearby. Due to the above circumstances, as well as defendant's suspicious behavior, the officer initiated a subject stop on the defendant due to reasonable suspicion. The officer activated emergency traffic lights and began sounding the siren of a marked patrol unit. The defendant continued to ride his bicycle away from the officer, standing up on the seat of his bicycle to accelerate faster. The defendant eventually fell off the bicycle and continued to evade on foot until he fell in the roadway of the 900 block of Pasadena Boulevard. The defendant evaded the officer for approximately 736 feet.
The hell was he doing wrong? Riding a bicycle while white? Not doing anything.
Here comes the judge's reality check. Every single day, someone dies in an alcohol-related crash. But this isn't just courtroom talk. It's straight-up life advice. In one powerful moment, legal warnings give way to raw truth about the human cost of impaired driving. It's a wake-up call for anyone listening. Why risk everything when a simple ride share could save lives? Think about your own choices. Have you ever been tempted to drive after drinking? Let's talk about that in the chat.
Presumptive police. No. Mr. Price, I'm going to find that there's no probable cause in your case today. We have enough death, dismemberment, and danger in our town as it is. Don't create any more. Be a good person. It's not hard. Get a job, do something with your life before something, or you end up with a 25-year sentence. It's lickety split. Something happens. Life is too short to end up in a 6x9 with a 25-year sentence. You know what I mean? Really. Please take a seat. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On March 1st, 2025, the officer observed a white Honda CR-V involved in a minor accident. The defendant was traveling southbound on Dennis Street when he struck a 2016 gray Lexus. The defendant admitted to consuming alcohol recently, and standard field sobriety tests were administered. HGN 4 out of 6, walk and turn 6 out of 8, one leg stand 3 out of 4. The defendant refused breath.
Hey, he admitted to consuming alcohol recently, so what?
And Your Honor, there are no other indications of intoxication listed in the DIPS.
No slurred speech, no bloodshot eyes, no,
We don't have that.
not even an odor of alcohol.
No, Your Honor. None
Your
of that.
Honor, what we do have is that there's an accident and when another officer told him that he thought that the defendant was intoxicated. We don't know what the other officer observed,
Right.
based on the DIMS
Yeah.
facts.
All right, I'm gonna find no probable cause. Mr. Medrano,
I'll explain.
hey, be careful, man. I mean, look, every single day, someone dies from an alcohol-related collision in our county. Every single day. $50, $40, Uber, anywhere you want to go. Don't matter where you want to go. You know what I mean? So, all right, good luck, please. You are Mr. Pavez Vargas.
Yes.
Sir, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 15th,
El 15 de febrero,
officers
los
observed
oficiales observaron
Nissan SUV failed to maintain a
que
single
no
lane
mantenía una vía
5 times
5 veces
and observed it
y
to slow down
observaron que
and
redujo la
rapidly
velocidad
accelerate
y rápidamente aceleraba
several times
varias veces
before initiating a
antes de
traffic stop.
iniciar el acto.
The officer observed the
El
defendant to be
oficial
confused
observaron que
and
el
delayed in
acusado
responding
se
to
tardaba
his
en
questions
responder a las preguntas
and struggled to locate his
y
driver's
luchaba
license.
para localizar su licencia de manejar.
The defendant
El
advised he
acusado
was coming from a wedding
dijo que venía de una boda
and he had one
y que
beer.
había tomado una cerveza.
Standard field
Le
sobriety
dieron
tests
las
were performed.
pruebas de campo,
4 out of 6,
4 de un 6,
HDN,
HDN,
4 out of 8,
4 de
walk and
monstruo,
turn,
caminar y voltear,
3 out of
y
4 one
3 en
leg
4
stand.
para dar una pierna.
The defendant consented to breath
El acusado dio permiso para dar su aliento
and he blew a
y sopló
.08.
.08.
You said that he
Eh.
5 times
5 veces
failed to maintain a single lane of traffic.
una vía de carril.
And you said that he slowed down
Su
and then
velocidad.
he sped up.
Yes, Judge.
What else?
¿Qué más?
Because as far as the 5, that's just completely conclusory. So I take nothing with it, right? I mean, everybody slows down, goes back fast. So
Bajan su velocidad.
what else do you have as far as any kind of traffic infraction other than that?
Y por
That's
parte
what
de
I'm
eso,
reading in
eso es lo que leo.
this, Judge. Let me see if there's
En
any
esto,
more
señor.
information in the office.
Su señoría, deje ver si hay que nos vamos en la defensa. Me responde.
It does say that
Dice
after the
que
emergency equipment was turned on,
se
the
prendió
suspect failed
el
to
equipo
pull
de
over for
emergencia.
approximately 2 minutes.
que él no se paró por aproximadamente 2 minutos.
I don't know if he articulated more maybe in an OR, but there's just not much there. I mean, Blaze, I can give you a little bit of time if you want to try to pull the OR, maybe like 10, 15 minutes.
Y más para que miren a ver lo que hay. Otros 10 o 15 minutos. Y que no se mantuvo en una vía, en un carro.
Okay. All right, Mr. Pavez Vargas, I'm going to find that there's no probable cause to go forward in your case. Sir, we have enough death and destruction on our streets as it is. Be mindful of this. If you want to have 15 beers, 32 shots of tequila, take an Uber. Save yourself the trouble.
Tal vez
Do you understand?
entiende.
Yes, sí.
Okay. All right. Thank you. Please.